Ed, thank you very much indeed for that, and welcome to the Mermaid Theater. For those of you who are not familiar with this theatre, it was opened in 1959, and as the Lord Mayor will know, it was the first theatre opened in the City of London since Shakespeare's time. Unfortunately, it's not used as a theatre anymore, but those of you from London of a certain age will remember Bernard Miles, who was the leading light, the actor behind this theatre, which was, when it started up, was just an old warehouse by the docks here, and he used to play Long John Silver in Christmas productions of Treasure Island, and school children used to come and marvel at his performances. And I think you're going to marvel at the performances that we have for you in the next hour or so. We are having this discussion to talk about legal aid, access to justice and pro bono. My name's Joshua Rosenberg. I profess to be a legal freelance journalist, legal commentator, and I've been invited to moderate the discussion today. We have four distinguished speakers, and I'll introduce them before just asking them a few questions and then moving on to a discussion which I hope all of you will join in. Nearest to me is Joe Hickman. Joe Hickman is a solicitor and head of casework at the Public Law Project, which is a national charity that aims to improve access to public law remedies. It takes on cases which are funded by legal aid. They're sometimes funded by grants from charitable foundations, and when they win their cases, they're funded by the other side. Before moving to the Public Law Project, she worked at the law firm Fisher Meredith and at the Refugee Legal Centre. She's a member of the Legal Aid Practitioners Group Executive Committee. Next to Joe Hickman is Yasmin Welji, OBE. Yasmin is International Pro Bono Manager at the law firm Hogan Lovells. Her appointment in 1997 as the first legally qualified full-time pro bono manager was the first of its kind in Europe, and she's still at Hogan Lovells. She was key to establishing and embedding a pro bono culture in what was then a city law firm, is now an international law firm. By background, she's a human rights lawyer. She's still winning cases. She's represented prisoners on death row in the Caribbean. She's advised the campaign to secure legislation for compensating British victims of terrorism abroad. Next to Yasmin Welji is Sir Robin Knowles, CBE. Sir Robin is a High Court judge. He sits in the Queen's Bench Division as Mr. Justice Knowles, and some of you know that the courts would soon be sitting this morning. They tend to open at 10:30, but his court is going to have to sit late because he's sitting with us to talk to us. Until his appointment at the beginning of last month, he was a QC, a barrister specialising in commercial and chancery work. He has a long-standing commitment to pro bono work, hence the honour, CBE, after his name. He's a trustee of LawWorks, the UK's leading pro bono charity for solicitors, in-house counsel, mediators and students. He's chairman of the Bar Pro Bono Unit and member of the Attorney General's National Pro Bono Coordinating Committee. And furthest away from me is Julie Bishop, Director of the Law Centres Federation, the representative body for the National Network of Community-Based Law Centres. Before that, she was Director of the National Association of Community Legal Centres in Australia. She worked in the legal aid sector in Australia, community level, for almost 20 years. Ladies and gentlemen, please welcome your panel. Now, we're really here to talk about access to justice and pro bono in the United Kingdom. I want to start with a bit of an overview. There have been, what I think is fair to say, pretty substantial cuts to legal aid here in England and Wales. On the other hand, there's also a very strong commitment to pro bono work among certainly everybody in this theatre and a lot of people beyond. As we've heard, the government has just come up with a bit of extra cash to support litigants in person. So what I want to start with is really, how good, how bad things are. I mean, Joe, could you start us off just very, very simply for the benefit of people from outside this jurisdiction? Tell us what's been happening over the last couple of years in terms of legislation and cuts.
Okay, so we started with The Legal Aid Sentencing and Punishment of Offenders Act, which was, I think, passed in 2012, came into force in April 2013. And what that act did was sort of fundamentally reverse how legal aid had been applied in England and Wales, certainly to date, because prior to that, the Access to Justice Act had said effectively legal aid was available for everything unless it was excluded, and there was a fairly short and fairly clear list of exclusions. What the Legal Aid Sentencing and Punishment of Offenders Act, which everyone calls LASPO, did is it said unless you're in, and there's a fairly detailed schedule of cases that are in, you're outside of the scope of legal aid. And if there's a majority of cases that were taken out, sort of large identifiable cases, obviously lots of sort of smaller things came out, were immigration cases, save for asylum, legal aid is no longer available there, private family cases, things like contact, residence, divorce proceedings, welfare benefits, debts, save where an individual's house is in, where they're at risk of losing their house, education and housing. So all of those areas of law, plus lots of other sort of smaller individual type cases, immediately came out of scope. There's a safety net provision in Section 10, or there's intended to be a safety net provision. I hope to get a chance to speak a little bit about that later, which says that where legal aid is, in a case that's out of scope, where legal aid remains necessary to ensure that there's not a breach or a risk of a breach of an individual's fundamental rights, either under the ECHR or under their sort of other sort of EU convention rights, legal aid ought to be made available under that section, but that's a separate thing.
So cuts, but a safety net. Yasmin, just tell us a little bit about the politics of legal aid, because it's going to be an election issue. We've got a general election here next year.
Absolutely. So when I first started out, Pro Bono was all about, or it was once described to me as making lawyers feel better about themselves, but actually that's pretty flippant in an environment where now there are many firms delivering, just like mine, about 100,000 hours of free legal advice. When I first started, it was really important, and still is, for me and for many firms, to think very carefully about where we apply our pro bono resource. And that's where the political rub comes. Because just today, and forgive me if I just praise the firm once, but yet just yesterday we won an appeal at the upper tribunal for ex-armed forces soldiers who are claiming a pension, a war pension, following the Christmas Island nuclear testing in the 1950s. We've won that case. There's still a long way to go. We've done over 1,000 hours over 3 years, and it's still going on. And the reason to select that particular area of need was because legal aid was never going to come back to that, and because it was a discrete area of law that we could specialise in. So we now, given the enormous cuts that are affecting legal aid, we need to think very carefully about where do we apply that service, that pro bono service. We know that the heart is being ripped out of legal aid. And so we need to think carefully about, are there any red lines beyond which we will not go as pro bono communities? Because effectively we are replacing the government's fundamental duty to provide a comprehensive legal aid service. And we have always said in the pro bono community, it is an addition to, not a substitute for, legal aid. Yes,
okay, I will certainly come on to that. I mean, I think that's the fundamental question that we want to talk about, that Yasmin has explained. If you do pro bono, does that merely encourage the government to make cuts? And we'll come on to that in a moment. But before we get to that, I want to bring in Julie. Tell me about the front line. What's morale like in the law centres?
Well, for those of you who don't know, is this too loud? Can you?
No, keep talking and
okay.
they'll adjust it.
Okay,
and if
thanks.
people can't hear, shout at the back and we'll fiddle with it.
Law centres, those of you from the States anyhow will understand the term poverty law. So the work of law centres is that we use legal skills to address the underlying issues and causes of poverty. Law centres have been around for over 40 years now, and our mission, in fact, is one about social justice and justice in the broadest sense. Hence, the cuts to legal aid, the biggest part that Joe referred to fell squarely within the work of law centres. 90% of the funding that law centres previously received from legal aid was taken out of scope with that change. This time last year, there were around 50 law centres Now 10 have closed. We anticipate maybe another 2 have closed. All law centres have shrunk in order to continue. And this isn't just something to go on. You're all used to the charitable sector whinging about money and what terrible things are happening to them. But I raise this in terms of the question about morale. We've shrunk in order to survive because we want to maximise the resources we have in order to still address the issues and the problems of those most in need. What was once around 120,000 casework clients a year, that's not people who knock on the door, has now gone down by over a third. We expect it to be down by a half next year. More importantly, one of our largest law centres told me just this week they now have to refer on 1 in 2 clients. Another one of our larger law centres, Islington, in terms of casework, that is representation and more than one-off assistance, is now down to 1 in 3 clients. What we're able to do with other funding, other than legal aid, has dramatically reduced what we're able to do. So focus and targeting those most in need is really critical. And as a result of this, the morale isn't as bad as you would think because we've turned to some quite interesting projects. And some of them are in partnerships with firms like Freshfields, Allen and Overy, and we can talk about those successes within it. But we need to be very clear, these are time-bound projects, they're very directed, they are not a generalised legal aid service. Access to justice and the rule of law in the UK at the moment is seriously under threat.
Okay, thank you very much. Robin, give us some good news. Tell us a little bit about government funding, about what you've been able to secure for litigants in person and so on.
I think there is, and it's vital we hold on to 2 things. First of all, there's a great deal that we can achieve. And secondly, the reality is we've got to make the very, very best of where we are. Even before the legal aid cuts, there wasn't enough legal aid. Even if we strain every sinew on the pro bono side and combine that with an improved legal aid system, we'll still be short of the goal that we all want to strive to, which is genuine access to justice for all of the people. That's why I celebrate, as a tiny example of sort of being practical and trying to achieve the best out of the various resources we've got, a recent development which has brought on the national side some of the leading charities that help deploy the profession on a pro bono basis, alongside some modest but significant government resource, so that we can develop the pro bono side of things in as strategic a fashion as possible. Doing that with government does help ensure a path to 2 essentials. The first is that we ensure that government continues to be close enough to be able to see what things are really like on the ground. And secondly, we make sure that we can help fashion the tools that we're going to need, whatever is available within the legal aid system, to make pro bono as smart as possible, to use Fiona Woolf's word.
Okay, well, look, I want to focus, I want to interrupt you there, and I want to focus our discussion a bit on a particular judgment. It's got quite a lot of publicity. It was delivered by Sir James Munby, President of the Family Division, a week ago. It's a case about a couple who have a son aged 2.5 who is threatened with adoption. Both the parents have what are described as learning difficulties, and the question for the local authority is whether this child should be taken away permanently from these parents. And as Sir James Mundby points out, with life expectancy as it is, this is a decision of the courts which may have repercussions into the next century. You know, his life expectancy could be as much as 100. So this is a very significant decision. The problem is that the father does not get legal aid. He has some earnings. He has enough earnings to take him just over the limit for legal aid. He has learning difficulties, so he can't represent himself. And the proposal is that his child should be taken away from him permanently, him and his wife. And there's some suggestion about the mother's parents looking after the child. There's some suggestion of a permanent adoption. It's a very important, significant thing. Taking a child away permanently from his or her parents is the most drastic power a judge has. The problem is that the father does not get legal aid. His solicitor has done more than 100 hours pro bono work on behalf of the father. This is a solicitor called Rebecca Stevens from a firm called Withy King. The judge is very complimentary to her for the work she has done in challenging the refusal of legal aid. And after the judge made it very clear that if nothing was done, he would try and either send the bill to the local authority, which is seeking to have the child adopted, or maybe to the court service or somebody, it was decided that the consequence was that some limited legal aid funding has been provided. So, thanks. So the question is this solicitor doing the right thing? There was a comment on the story on the website of the Law Society Gazette, which is a trade paper, saying this solicitor should be struck off for undermining the whole of the family solicitor's profession by working for nothing. On the other hand, you know, the judge is clearly complimentary, but he doesn't think that we should be in this position. Now, that is the dilemma, isn't it? You're all nodding. Who is going to tell me what this solicitor, faced with a client, a man who is at risk of losing his child permanently, what should this solicitor do? Does she campaign for legal aid, work unpaid, paying her own travel expenses and everything? Does she simply say, tough, you know, I'm not being paid to do this? Does she make a fuss? And what does she do? Julie.
Yeah, well, Joshua, obviously this is the reality of every day at a law centre. We walk a real tightrope about at what point do we work for free, at what point do we bring in pro bono, because we are mission-driven organisations. What we want to do is maximise the number of people we're able to assist, but more importantly, we're not about numbers, we're about having impact. And I suppose there's another case that I would like to add to this, which is, again, a live case that Joe knows about, where the comment was made by the legal aid agency that the client involved did have the possibility of a fair trial because it was possible that they could get pro bono support. So it's not simply cases like this, it's also the legal aid agency, the Ministry of Justice, saying that fair trials in this country now can be achieved through pro bono support. Hence the issue for us. At what point do we take on pro bono support? At what point do we turn people away? And I think one of the skill sets at law centres is in also dealing with vulnerable people. We have to make a judgment at what point that person cannot assist themselves, at what point they do need additional skills, but more importantly, we're making day-to-day decisions about what the impact of that case will be. What is the public interest to be gained here? In the case that we're talking about now, the immigration case where legal aid said that pro bono was possible, there has been an immediate benefit, and that immediate benefit is that family reunion in immigration is now brought back within scope to legal aid. Now, that'll probably go again, but these are the sort of judgments we make.
All right, I'll bring in Joe Hickman at this point.
I have a little bit of personal involvement with that case. PLP was asked to consider what the situation was. And just to clarify, I think my understanding of what Rebecca Stevens did was she didn't do one or other, she did both. And that's exactly, I think, what practitioners ought to be doing, is she sought to protect her client's position valiantly in a way that a lot of people simply won't have the resources to do, but she did that. She also sought to challenge a position that she saw as unjust, and I think that was ongoing throughout. So it wasn't that she was sitting back and saying, well, we'll just provide the services pro bono, and it also wasn't that she was saying, well, we'll take a point of principle and the client's rights can go hang while we do it. So I think that is a really important illustration of what we ought to be doing here, and what everyone who's practicing, certainly in pro bono in the UK, needs to be thinking about now, is that the new legal aid landscape means that it's much less straightforward to identify those cases where legal aid ought to be available under statute. And I don't come from a pro bono background, and I wasn't familiar with the pro bono protocol that Fiona Wolf cited earlier, but I understand that this definition, it's not pro bono if public funding is available. And if public funding is available under Section 10 of LASPO, or ought to be available under Section 10 of LASPO, or ought in any event to be available under Article 6 of the ECHR, then you shouldn't be doing pro bono, it seems to me. And that the art in devising projects, in doing the work that we do, is to ensure that individuals, rights of indicated individuals, positions are protected at the same time as the mechanism, such that, it may be limited, but the mechanism that's left in force to provide state-funded representation is in force where it ought to be.
Okay, Yasmin, what would you do in these circumstances?
I think it was interesting in this case that there was a solicitor available with the skill set necessary to represent the client. There's so often, and in major city firms such as ours, we just wouldn't have the expertise to be doing that, and therefore we couldn't help out directly. And that's the big problem, is that you've got a mismatch between the need and the skill set that's available. And do you then train an M&A lawyer to do something as sophisticated as a case such as this? Absolutely not in my view.
Well, hang on. You say that, but law firms are training their staff to do discrete areas of welfare law. City law firms, commercial law firms are bringing in an outside instructor provided by an organisation like LawWorks to train up their staff so that they can, if you can do mergers and acquisitions, you can do housing law.
I think, well, you take a family law and say do some mergers and acquisitions work. I think it's really challenging. There are some parts of sophisticated family law that are really, really specialist. That's why people go to law school and do this as a career. For many years, you just can't step in and take over. So I think there's a really interesting question for us as to how we support community organisations in those cases, and lawyers taking and retaining their skill set to be able to do those cases. So yes, of course, we can take out discrete cases, just as my Royal British Legion case, but there are certain ones where perhaps we need to be working in partnership with the legal aid community to look at the policy issues of how we measure the impact of the value and demonstrate that to government by actually supporting them through perhaps a test clinic. So we're looking at who's actually missing legal aid and putting some structure around that we can then put the argument alongside the legal aid community to government to fund that particular aspect and try and restore it. But to ask us to step in and try and help out in these cases, I think is actually fundamentally quite dangerous.
Julie?
Thanks, and to add to that, there are 4 key issues that impact on this. Sure, you can skill up people to do a triage session or a clinic. We would love to be able to skill up people to do a lot more than that, but we have 4 barriers. The first is urgency. There are often clients that we need someone for immediately, and it just simply isn't possible to pull someone out. There's the issue of resourcing in order for the supervision, the hosting of the clinic and the skills, but most importantly of all, there's something to do with the client relationship and that long-term relationship. And so while pro bono is excellent for certain sort of scenarios, there are many cases where when I say law centres have expertise in poverty law, that also includes expertise in working with particularly vulnerable people. If the client doesn't trust the lawyer, they are not going to get the whole story. If you do not get the whole story, you cannot fully represent the person.
Okay, I'm going to bring in Robin, and then I'm going to come to the audience for comments and questions. Robin, you're going to encounter this problem at the sharp end. I mean, I know you're not going to be sitting in the family division, but if you're sitting in the High Court in public law cases, you may find yourself with litigants in person. You may find one side is unrepresented. You may find both sides are unrepresented. And the system in this jurisdiction depends on the judge, that's you, being told by the lawyers about the law and the arguments and so on. It doesn't depend on you being inquisitorial and questioning both the parties in front of you, or the several parties in front of you, to try and find out what the case is about. And that's the way it seems we're going.
Well, this is why the challenge in this jurisdiction, and I suspect across the world, is so fundamental. We have got to, and we've got to include the judiciary in meeting that challenge. That requires, amongst other things, the judiciary to know much more about what resources can be available to assist people that are necessarily brought into the system. Every judge who finds a litigant in person in a case in front of them should know all about not the possibility of a lawyer being found on an ad hoc basis, but about what is increasingly a collaboration across the entire profession, the bar, the solicitors, the legal executives, and in conjunction with the advice sector. That's the way that we will be able to bring the right specialism to support in the right case. It's also the way in which actually the M&A lawyer can develop the secondary specialisation, not alone, but in conjunction with others within the profession. So large is this challenge that we owe it to ourselves and to everyone in the country to collaborate and cooperate and be strategic, including the judiciary. If I can just say one thing about the case that Joshua began with, and Rebecca, the lady in that case. What should she do? Exactly what she did. What is one of the many things she achieves in doing that, and that case has achieved? It has helped bring across to the public and everybody else that actually legal aid provision and pro bono provision, but legal aid provision in particular, is about getting help to people. It is not, and we've fallen into a trap in this country in seeing it this way, it is not about what the lawyers are getting paid. And the moment you realise that legal aid and pro bono together is about helping people to access justice, is the moment that we should be proud to do as much pro bono work as possible. We should be relentless in our expectation of government to see legal aid as a priority to serve the population as a whole. And we should be realistic in knowing we need the maximum in both areas.
Okay, I will bring in the audience now, and this is fairly open. This is up to you. You can either comment on the dilemma we've just been discussing, you can challenge the panelists on what they've said, or you can ask for information. If you come from a foreign jurisdiction and you want to know how things are done here, now is your chance to learn a little bit more about what goes on here. And I may take several comments and invite the panelists to make notes and then deal with several questions at a time. We do have microphones so that everybody can be heard, and we are recording this as well, so please wait for the microphone. Please give your name. Who would like to make some comments, please? There's a lady over there, that's number 2 microphone, and yep, go ahead. And give your name if you'd like to.
I'm Lizzie Iron, and I work for the Court-Based Personal Support Unit, which is one of the... This feels very echoey.
No, it's fine. We can hear you very well. Go ahead.
It's one of the charities that is benefiting from the new money announced by the MOJ. And we work on the principle that, just picking up the point about specialisation, the law needs to be delivered by lawyers, but a lot of the process around the law can be done by other people. So the Court-Based Personal Support Unit helps people in court going through all the process apart from giving legal advice. So we give emotional support, practical support, we help people work out how to fill in their forms, and we will sit in court with them, but we don't represent, and we then work with them afterwards just to make sure they've understood the outcome of the hearing and help them work out their next steps. So we help litigants in person represent themselves better.
Okay. Good, thank you. Another comment. Right, a lady in black here, and this will be microphone number 3 is coming to you, and then after that, somebody 2 behind.
Thank you. Alison Harvey, Immigration Law Practitioners Association. One of the big things that we have lost in the UK with the cuts to legal aid is the loss of pro bono hours, because most legal aid lawyers, for each pro bono fee, did many more hours work on the case than the nominal amount represented by that fee. So we have seen a massive reduction in the work being done pro bono. It is time for the professions in the UK, the Bar Council and the solicitors' profession, to step up and require pro bono as a condition of the practicing certificate. And I'm quite happy to see a carbon offsetting approach. Those who do not want to do it themselves are welcome to fund hours of Julie and Joe's work instead. That would support the law centres. But we are now at the stage where we need that, and the professional bodies need to step up to the mark.
Okay, and just 2 behind you, Catherine, I think.
Hello, Catherine Baxi, freelance journalist. Following on from Alison's question, really, given the scale of the need, should pro bono be compulsory? And for delegates from other jurisdictions, is anybody aware of jurisdictions where it is compulsory?
Okay, so there's 2 questions about whether pro bono should be compulsory. Is anybody who wants to talk about that particular point? Either, should pro bono be compulsory? Is it compulsory in your part of the world? Or is it inconsistent? Is there somebody? Yeah. That's microphone number 2. Is going to the lady in red there.
In South Africa, it is compulsory. All attorneys, which is solicitors, have to do 24 hours pro bono work a year, and all barristers 20 hours per year. Some of us don't like this because we think pro bono should be done on a voluntary basis, and it should be something people choose to do. However, it has been very effective, and in a sense, many lawyers are doing more than that, but at least some and most are now doing at least that. And it does start to build a culture of pro bono, so there are definite advantages.
Okay, I'll take some quick comments from the panel, really on this point about whether it should be compulsory, and perhaps a related question of whether law firms are doing enough, I'm thinking of the large corporate firms, by the extent to which law firms say that your pro bono work counts towards your billable hours, the extent to which it counts towards, I don't know, your pay and pension. In other words, is there more that the commercial law firms could do to encourage their staff to do pro bono, even if it's not compulsory? So who wants to comment on that? Joe, yeah, okay.
Well, I think, for me, the starting point is we have an adversarial legal system. We have a sort of legal economy that's regulated by the market. Everyone accepts good legal advice costs money, access to justice costs money. Now, personally, I have no ideological position as to how you ensure that equality of access is ensured, whether you do that through a state-funded legal aid scheme, whether you do that through compulsory pro bono. What is essential is that you have to make sure that the rich don't have greater rights of access, that the rule of law applies equally to everyone who is subject to the law. And what's essential is that you find a way and you find a scheme that makes sure of that, and we don't have that right now.
But the specific question is, should it be compulsory? Should it be a condition of your practicing certificate as a solicitor or as a barrister?
Then you make a pre-assumption that if that is a prerequisite, if that is how this functioning jurisdiction decides that it is going to ensure access to justice, then you make it compulsory. And you not only make it compulsory to do it, but you make it compulsory to do it to a degree and to a standard that actually ensures that the individual who you're acting for's rights are vindicated. Because doing a nice little workshop in social welfare law, it might be nice for city lawyers, but it only counts if at the end of it, the individuals whose rights you're looking to protect are properly vindicated and they have their proper legal rights of access to the court. So, I mean, for me, it's it's taking the question a step down the line. The point is you have to ensure that there's equality of access.
Okay.
And you
Yasmin.
do that one way.
Yasmin, should it be compulsory?
I'm not in favour of compulsory pro bono because I feel that the heart of a volunteer is much more passionate if they're being driven by their volunteering aspiration to want to help. But I do believe that we need to institutionalise the idea of a target, and we need to build it in within the institutional framework of law firms. So our firm, for example, will give 50 hours towards the billable hour target in order to do pro bono work, but that's just a floor. We can go way beyond that. And I think there are too many firms at the moment that are mixing up pro bono community affairs. It's a little bit woolly, and so many of us have got together around a collaborative plan to ensure that there is quality around what we deliver, to make sure that we actually do end-to-end casework and there is an impact from it. It's not just a workshop or sending a lawyer down for a half hour to point them in a direction of a service that's already too full to take them. It's really, really important that we institutionalise it at a corporate level, but actually it should be down to the volunteer lawyer because it's a special skill to be able to deal with the vulnerable, as Julie has said. That's
okay.
where I stand.
Robin, you're the barrister's profession that you used to adorn until a month ago. There are an awful lot of barristers there who, on being told that pro bono is going to be compulsory, would look for a way of challenging that in the courts. They'd try and get out of it, wouldn't they? They don't want to do that.
Pro bono work is part of being a lawyer. That's the key. Not to make it compulsory, but actually for the professions to live, eat, breathe, and believe that pro bono is part of being a lawyer. That requires leadership from the top of each of the professions, each of the firms, each of the sets of chambers. It requires celebrating and nurturing the energy and willingness that is there as people enter the profession. If we made a pro bono compulsory at whatever level of hours you want, we'd end up over time, and we've got to look at this in the long term, we'd have ended up setting a limit, and setting a limit that people put up with. The opportunity is there for us to make this something that continues to feed the sense of genuine professionalism and willingness to serve the public that is the hallmark and should be the hallmark of a legal profession around the world.
Okay, Julie, thank you.
I have seen a mandatory system work, and I've seen it work well.
Where was that?
In Australia, I think John Corker's in the audience. He can talk about the introduction, the sort of arguments around that, excuse me, are very familiar. And in fact, I was, I was of the view that, thanks. I was of the view that it shouldn't be mandatory when it came in, and I argued indeed with John against it. But in fact, what I saw, that it did in fact encourage much more a culture of, it didn't dampen pro bono. It didn't make people just do their 20 hours. People actually engaged in it in a new way. I agree with Robin that being a pro bono is part of being a lawyer, but that's been part of being a lawyer for many, many years, and everyone isn't doing pro bono. There are two warnings in relation to this. Number one is that if you set a target, people will meet the target and find a way of doing it, regardless of doing what's required. So how do you mitigate against that? We need to be very careful with what is regarded as pro bono. And from a law centre's point of view, sitting on a school board, being in the Scouts because you're a lawyer is not pro bono. It needs to be an active legal intervention, and I think we have to be clear about that as well. Secondly, I wholeheartedly support the carbon offsetting, because I would like to add that as law centres we benefit to the tune of 25% of our income now is in kind. That comes from the generosity of the firms in many, many ways. We don't want to limit pro bono entirely. Once we get a target, we want the in-kind to continue as well.
And when you say carbon offsetting, you're talking about law firms actually saying that pro bono work counts towards billable hours or targets or whatever.
Yeah, and we don't want to do it, so we'll give you £100,000. Julie. Thank you.
Okay, gentleman there, please. Microphone, please, to the gentleman in the middle there. It's microphone 2 is winning. Microphone 2 is coming along to you, sir. Go ahead, and then...
Thank you. My name is David Hillard. I'm the pro bono partner at Clayton Utes in Australia. And as an Australian, I speak to you as the ghost of Christmas future. We've had the LASPO cuts in place effectively in Australia since 1997. And the profession has changed a lot in its attitudes and conduct of pro bono over that period of time. The one thing that has concerned me in the past week, while I've been here listening as an outsider, is I think there is a real risk in England and Wales of vastly overstating to your own detriment the amount of pro bono and the impact which it can have. We've fought, I think, a very good fight in Australia to persuade government that pro bono is important, but it's such a tiny piece of the access to justice response. And with the greatest of respect, it terrified me to read and to hear the Law Society celebrating over £600 million worth of pro bono work being done. That seems to me to be an illusory number, but also really something which is set to ensure that you will never get your legal aid money back.
Okay, thank you. Microphone number 3 is coming down to here. Gentleman here, looks to me like Geoffrey Forrest.
My name's Geoffrey Forrest. I'm a Law Society council member. I'm also from a smaller firm background. This question of should pro bono be compulsory comes round again and again and again. My personal view is absolutely not. And without deprecating the very fine work that's done by the kind of commercial firms who are part of PillNet and support its aims, I think, if you suggested to a smaller firm or a criminal legal aid practice, you've got to do compulsory pro bono, they would be appalled at the thought, because of course they're doing it anyway, such as in the case of Rachel.
Okay, and lady in the blue over there, please. The same microphone 3. Lady I thought it was you. Didn't you want? Okay, the gentleman there with his hand up. Microphone number 3, and then. Okay, go ahead.
John Corker from the Pro Bono Sector in Australia, just having been mentioned by Julie, I think maybe the aspirational target scheme that David mentioned that's been running since 2006 has been so effective that you maybe thought it was mandatory. I assure you it is an aspirational target. It's very much 95% carrot, 5% stick. We just put out the 7th annual report of that target and showed that 17 of the top 20 firms are now signed up to that target and 60% of them are meeting it. That's a target of 35 hours per lawyer per year. And the other point I'd make is that within that, it doesn't change the fact that government bears the primary responsibility for looking after its citizens and looking after their legal needs. And that always remains central. So I was really interested, particularly in what Yasmin said and Robin, about what is the role of the pro bono sector within that context Is it a matter of clarifying what ought to be legally aided? That question remains. It will always remain. And maybe that's where some of that pro bono capacity can be used, that the judiciary understands that. I think that's the direction that you should be looking at, not this issue of mandatory and voluntary. It's past. It should be put to bed.
Thank you. I've got some questions over there. There's one over there. This is microphone number 2. Lady there with her hand up, please. Just there. Put your hand up. Grab the microphone. That's it. Go ahead.
Thank you. I hope briefly. It's Cathy Gallagher from the Law Centres Network. Just to comment on the points made by the last few speakers, is all those theories about whether to be compulsory or not are to do with the work. One of the things I would say is that not at the present time. It could be aspirational, yes, but particularly because the last election manifesto of the current main partner of the government was to require commercial firms to provide pro bono. Law Centre staff are very concerned about the potential mission drift in that this will definitely be in the next manifesto. And look, we've persuaded pro bono to start talking about compulsory hours. So I would suggest be aware of the law of unintended consequences in moving in that direction, and with the current political atmosphere of requiring the legal fraternity to take on the government's role of providing support in access to justice. Otherwise, you will all be giving opinions on the law of unintended consequences about what happened there. Right. The other issue is about the effect of practising certificates. And just 2 points I wanted to add, which is really what I want to make the point on. If you could pick up perhaps in your comments about whether or not there are practical things, should there be a time limit, for example, picking up John's point about the amount of time in pro bono. Should there be a time limit, and recognising that there is a tiny contribution to access to justice overall, plus the drift towards the inquisitorial approach, should that be a structural approach that we should be campaigning for?
All right. Thank you very much indeed. And there was a gentleman there in the blue shirt, microphone number 2 again, just there. Yep, go ahead.
Thank you. James Sambach from the Legal Action Group. We are Men Access Justice charity. And I previously used to work for Citizens Advice. Now, there's been most discussion so far has been about the relationship between pro bono and legal aid, and how can pro bono strategically supplement what legal aid has previously done. But also, I think you can reverse that and say, well, there are always going to be legal aid cuts because of the economic situation the government was in, but of what's left within the legal aid scheme, simply in terms of the funding, which is it's 1.5 billion, which is divided rather unevenly between civil and criminal work. I wanted to ask the panel, is there actually a way that, how would they like to see that money? Do they think that there is any way, in any ways, and that money could be spent differently in a more strategic way, in a way that actually strategically the legal aid system could be supporting pro bono as well?
Okay, thank you very much indeed. Lady here, sorry. The microphone number 3 is coming down to this lady with a hand up here.
My name is Sarah Chandra. I'm council member of the Law Society for solicitors who work in the voluntary sector, being solicitors in law centres and legal advice centres in the university sector. My question is about the role of us in the pro bono community in engendering the culture of pro bono, but also engendering the spirit of campaigning for legal aid, because I'm particularly interested in the role of younger members of the profession, those in young legal aid lawyers, those in the Justice Alliance, who campaign as much as they can every day, every hour, to put the brakes on the cuts in legal aid and to see how we are going to reinstate access to justice for all in the future.
Okay, I think
really interested in what the panel think about that.
Right, I think that's probably all we've got time for in terms of questions, and what I'm going to do is I'm going to give each member of the panel a chance to pick up as many of those questions as they can in the couple of minutes that each has. Australia, don't delude yourself into thinking that pro bono does a lot. It's aspirational, law of unintended consequences, better way of spending the money, and how we get young people to campaign for legal aid. Robin, why don't I start with you for a change? So go ahead, see what you can answer.
I think the point that I would like to emphasise, which I hope may harness some of the themes that were brought out, and this may be controversial, but let me see what you make of it. I think we've got to get used as a pro bono movement, a pro bono sector. We've got to get used to being ready to work with government, to have a dialogue with government about how legal aid, in whatever amount that is at a particular time, can be most effectively used. I don't think in this country we've ever got it right in terms of using the legal aid fund in the best way. But it's now more imperative than ever. The point was picked up about the interface, if I might use my word, between legal aid and pro bono work. I think we're at the time when that dialogue can happen, because we know, as a result of the progress of the journey so far in terms of collaboration and coordination, we know much more what we're talking about. And I believe in this country, one thing government would accept is that we know, that's the profession as a whole and the advice sector and others, we know what we're talking about. One of the dimensions of the new strategic initiative in relation to litigants in person that Joshua asked me to touch on in the beginning and was mentioned by one of the questioners, this provision by the MOJ of some resource to enable some of the key organisations, starting with the Personal Support Unit, up through the RCJ Advice Bureau, through Law Works, through Law for Life and more. But that's not just about putting a sum of money alongside those organisations working collaboratively. It also actually is the beginning of a series of conversations in which the Ministry of Justice is invested and able to listen so that it can hear our collective constructive ideas about how to place legal aid. If, just very briefly, if that journey is harnessed with a journey of trying to ensure that everybody understands that this is about getting justice to people, the lawyers are only a piece in that. It's about getting justice to people. This is the path that one day in this country we'll see a return of some legal aid in areas where it's been removed.
Okay, I'm going to stop you there, Robin. Yasmin, work with the government rather than work against the government.
The primary responsibility for the provision of a comprehensive legal aid system is with government. We can't talk about the Magna Carta and not absolutely make government accountable for those obligations. The AG used to turn up and always say that, always say it was addition, pro bono was an addition to, not a supplement for, not a substitute for legal aid. He didn't say that this morning. It was really noticeable. Okay, so I fear Robin's approach of cooperation with government is too soon. We have to help government understand, because at the moment they are not listening, about what is missing, the fundamental obligation they have under international law, under our historic law, to provide a comprehensive legal aid system. And I just fear you're conceding too soon on this to work. We always said that the spending cuts were going to reduce pro bono, because actually the law centres would have to work hand to mouth to try and keep themselves going, and actually couldn't usefully use the volunteer service that the city law firms and the other commercial law firms had. And that's happening. We are increasingly finding that we are actually having to go into the grassroots and try and make contact ourselves with individual clients. We need to properly fund the law centres so they can act as mentoring institutions for us as well on the discrete areas of law that it is appropriate for firms like ours to be involved with.
Okay, I'm going to stop you there, Yasmin, because we're nearly out of time. Joe, quite briefly, on where do you stand on this?
So, quite briefly, in picking up a sort of couple of the points, I think something that we didn't really talk about was LASPO was presented as an austerity measure. 8 days after LASPO came into force, there was a series of further legal aid reforms, some of which was to come in, most of them dubious or unquantified savings, all of which are sort of ideologically creeping at attacking the legal aid system in various ways. Last year, recent statistics suggest that there was an underspend in the sort of MOJ by quite a considerable amount, millions, I can't remember the figure, but a considerable amount. It's unsurprising when you think that MOJ expected there to be 3,500 exceptional funding grants. So when they took all these cases out of scope, their own estimations were that 3,500 cases would come back into scope under the Section 10 provisions. There were 15 in the first year of LASPO, 15 civil grants. So we're not just talking about cuts, we're talking about cuts that are potentially being implemented unlawfully. And I talk to government a lot, and I agree that there should be a dialogue, and I think sometimes that dialogue needs to be as claimant and defendant. And when we have a Lord Chancellor, and when we have a Ministry of Justice, and when we have a legal aid agency that have a legal aid scheme, it may not be ideal, it may not be any of us would like to see, and there may be a very valid policy and a campaigning reason to push for an extension, but we have what we have, and I would say that even what we have is not being implemented in a way that provides access to justice where it should and where it is accepted that there are obligations.
Okay, I'm going to stop you there and I'm going to bring Julie in here. You can see where the audience's sympathies lie. Where do you stand?
I'll just make 2 points. The first is that I agree with what Jo said, and she reminded me of something that I've said many times, and that is that the cuts to legal aid are not about austerity. Anyone who thinks that fails to understand the role of the current government, which is about shrinking the state and redefining citizenship. We work with the poor, we represent the poor. At the moment in England, the gap between high wages and low wages is now at 112, and at the start of the economic crisis, it was 1 to 45. What has been removed from legal aid has been the removal of the people we work with, the communities that we work in, to try and maintain a dignified life. So I'm going to come back, in fact, to the doctor who spoke earlier, and to say that from Law Centre's point of view, from our community's point of view, the true role of pro bono, compulsory or not, is that of accompaniment, that of focused accompaniment. The projects that work best for us are the strategic projects where we know the aim that we want to get at. It involves individual casework, but at the end point there's some sort of law reform or procedural change that can make a difference, that can prevent, and at the end of the day can really make a difference. That's what we would like to encourage, and I would absolutely like to end by thanking you all, because we wouldn't still be here if it wasn't for the support of legal firms. And it has been more than pro bono. It's been across the board. Thank you.
Okay, well, thank you very much. I'm conscious that I'm keeping everybody from their coffee. I'm going to hand over to Atanas and Marianne, who are going to tell you how the rest of the day works. But before we leave the platform, I'm sure you'd all like to thank the speakers very much indeed for their contributions.